Copyright infringement 50 languages article talk read edit view history tools from Wikipedia, the free encyclopedia for information on handling copyright concerns in Wikipedia. See Wikipedia. Copyright violations. An advertisement for copyright and patent preparation services from 1906. When copyright registration formalities were still required in the U.S. Intellectual Property Authors' Rights Copyleft Copyright Database Right Farmers' Rights Geographical Indication Indigenous Intellectual Property Industrial Design Right Integrated Circuit Layout Design Protection Moral Rights Patent Peasants' Rights Plant Breeders' Rights Plant Genetic Resources Related Rights Supplementary Protection Certificate Trade Dress Trade Secret Trademark Utility Model Related Topics Abandonware Brand Protection Copyright Abolition Copyright Troll Criticism of Copyright Via Prospecting Idea Expression Distinction Limitations and Exceptions to Copyright Fair Dealing Fair Use Paraphrasing Right to Quote Orphan Work Patent Troll Pirate Party Public Domain Outline of Intellectual Property Outline of Patents Higher Categories Property and Property Law VTE Copyright infringement, at times referred to as piracy, is the use of works protected by copyright without permission for a usage where such permission is required, thereby infringing certain exclusive rights granted to the copyright holder, such as the right to reproduce, distribute, display or perform the protected work, or to make derivative works. The copyright holder is typically the work's creator, or a publisher or other business to whom copyright has been assigned. Copyright holders routinely invoke legal and technological measures to prevent and penalize copyright infringement. Copyright infringement disputes are usually resolved through direct negotiation, a notice and takedown process, or litigation in civil court. Egregious or large-scale commercial infringement, especially when it involves counterfeiting, is sometimes prosecuted via the criminal justice system. Shifting public expectations, advances in digital technology and the increasing reach of the Internet have led to such widespread anonymous infringement that copyright-dependent industries now focus less on pursuing individuals who seek and share copyright-protected content online, citation needed, and more on expanding copyright law to recognize and penalize as indirect infringers the service providers and software distributors who are said to facilitate and encourage individual acts of infringement by others. Estimates of the actual economic impact of copyright infringement vary widely and depend on other factors. Nevertheless, copyright holders, industry representatives, and legislators have long characterized copyright infringement as piracy or theft, language which some U.S. courts now regard as pejorative or otherwise contentious. 1, 2, 3 terminology. The terms piracy and theft are often associated with copyright infringement. 4, 5. The original meaning of piracy is robbery or illegal violence at sea. 6. But the term has been in use for centuries as a synonym for acts of copyright infringement. 7. Theft, meanwhile, emphasizes the potential commercial harm of infringement to copyright holders. However, copyright is a type of intellectual property, an area of law distinct from that which covers robbery or theft, offenses related only to tangible property. Not all copyright infringement results in commercial loss, and the U.S. Supreme Court ruled in 1985 that infringement does not easily equate with theft. 1. This was taken further in the case MPAA versus Hotfile, where Judge Kathleen M. Williams granted a motion to deny the MPAA the usage of words whose appearance was primarily pejorative. This list included the word piracy, the use of which, the motion by the defense stated, serves no court purpose but to misguide and inflame the jury. 2. 8. Piracy, pirated edition of German philosopher Alfred Schmidt, Amsterdam, c. 1970. The term piracy has been used to refer to the unauthorized copying, distribution and selling of works in copyright. 7. The first use of the word pirate itself to describe unauthorized publishing of books dates back to at least 1736. As attested to in Nathan Bailey's 1736 dictionary in Universal Etymological English Dictionary, one who lives by pillage and robbing on the sea. Also a plagiary. 9. The practice of labeling the infringement of exclusive rights in creative works as piracy predates statutory copyright law. Prior to the Statute of Anne in 1710, the Stationers' Company of London in 1557 received a royal charter giving the company a monopoly on publication and tasking it with enforcing the charter. Article 61 of the 1994 Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, requires criminal procedures and penalties in cases of willful trademark counterfeiting or copyright piracy on a commercial scale. 10. Piracy traditionally refers to a